Hello, how are you? My name is Antonella, and today I'm going to talk about the Supreme Court's Facebook versus Jogir case. I'm going to follow the case brief structure. First, I'm going to talk about the facts, then I'm going to talk about the issues. Afterwards, I'll talk about the holdings, and last but not least, I'm going to talk about the reasoning. So, first, let's talk about the case. What is the case about? I'm going to talk about the facts. So, starting in 2014, Noah Dugir began receiving text messages on his cell phone from Facebook, warning him about suspicious account activity, despite the fact that he didn't have a Facebook account. So Dugir reached out to Facebook to rectify the situation, but Facebook did nothing to stop these messages. So afterwards, Dugir filed a class action lawsuit in March of 2015, asserting that Facebook violated the autodialer statute of the Telephone Consumer Protection Act of 1991 because the messages he received were being placed by an automatic telephone dialing system. So he alleged that Facebook violated the TCPA by maintaining a database that stored foreign phone numbers and programming its equipment to send automated text messages. So Facebook replied to this and said that the TCPA does not apply because the technology Facebook uses to text Dugir did not use a random or sequential number generator. So later we're going to see that this is the definition provided by the TCPA. So now, let's talk about the issues. Let's talk about the issues of the case. So I found two issues in this case. The first issue is whether the technology used by Facebook is considered to be an automatic telephone dialing system according to the Telephone Consumer Protection Act, and whether the TCPA definition of an automatic telephone dialing system includes any device that can store and dial stored numbers. Those are the issues. And now I'm going to talk about the holdings. So what is the decision made by the Supreme Court? So in this case, the court found that under a statutory interpretation of the TCPA, the dialing system used by Facebook did not qualify as an automatic telephone dialing system and stated that only systems that have the capacity either to store a telephone number using a random or sequential number generator or that produce a telephone number using a random or sequential number generator can qualify as an automatic dialer under the TCPA. So the court established that Facebook did not qualify according to this definition. Now, what is the reasoning of the court in this case? So, like I said before, the TCPA defines and dial system. The definition provided by the TCPA for the dial system is an automatic telephone dial system is a piece of equipment with the capacity both to store or produce telephone numbers to be called using a random or sequential number generator. So to qualify as an automatic telephone dialing system, a device must have the capacity either to store a telephone number using a random or sequential generator or to produce a telephone number using a random or sequential number generator. So the court established that because Facebook's notification system neither stores nor produces numbers using a random or sequential number generator, it is not an autodialer. So it also says, the court also says that the clause hangs together as a unified whole using the word or to connect two verbs that share a common direct object, telephone numbers to be called. it will be ought to apply the modifier to only a portion of this cohesive proceeding clause. So in this case, the court applies the series qualifier canon to interpret statutes. So what is this about? The series qualifier canon is a principle of statutory interpretation, and it says that when there's a series of connected nouns or verbs followed by a modifier, that modifier or qualifier normally applies to all of the preceding nouns or verbs. And that is actually really logical in English. So the statute defines an auto dialer, which is kind of a robot dialer, as like I said before, equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator, and then to dial such randomly sequenced or generated numbers. So here, Duguid, the plaintiff, in this case, took the position that the modifier using a random or sequential number generator only applied to the ability to produce telephone numbers. He took the position that it didn't apply to that portion of the statute concerning storing telephone numbers. So here, in other words, according to Duguid, it didn't matter whether the numbers were stored using a random or sequential number generator. It only matter if the numbers were produced using the random or sequential number generator. So here, in this case, the court establishes that Duguid's interpretation is actually contrary to the ordinary reading of the text. And he classifies almost all modern cell phones as autodialers, and that will produce an outcome that makes even less sense. So here, the court agrees with Facebook. They apply the series qualifier canon to interpret the statute and held that the modifier applied to both producing and storing numbers. So finally, according to the Supreme Court, an autodialer is equipment which has the capacity to not just produce telephone numbers using a random or sequential number generator, but also to storing numbers, random or sequential number generator. So in other words, to be an autodialer, the equipment must use a random or sequential number generator to store telephone numbers, and also to use a random or sequential number generator to produce telephone numbers. So here the court agrees that Facebook is not considered to be an autodialer, and this is not an automatic system according to this interpretation and according to the definition of the TCPA. So that was all. Thank you so much for your time, and I hope you enjoyed this video and this case brief. I will stop sharing my screen, and now I will stop recording. Thank you so much.